Tomorrow, I go to court for my 5th hearing before the final hearing on March 1st, 2024 with Judge Craig DeThomasis, otherwise known as Judge Grudge, because he holds a grudge, because there's a YouTuber acting as a citizen journalist. I got the biggest story in the tiniest little town in Florida. I've got major concerns about Judge Grudge, Judge Craig DeThomasis. As a matter of fact, as we look forward to what's going to happen in court tomorrow, let's take a moment just to look at his past history. He used to be a criminal defense lawyer with none other than his best bud, Joshua Silverman. Why would the Judge Grudge, why would Judge Craig DeThomasis allow this to keep going on and on and on for months? Is it for fame? Does he want to be on YouTube? Well, the reality is he's already created his own fame. Back in 1999, there's an entire documentary called Question of Consent, A Raw Deal. Judge Craig DeThomasis, who was not a judge, even though in one of the hearings he states, for 40 years I've been in the courtroom. Yeah, not as a judge. He misrepresents, or maybe we're misunderstanding, and it's as simple as a misunderstanding with communication. The reality is this: he used to be a criminal defense attorney, good buds with Joshua Silverman, the attorney that now represents LIEnette. And back then, he represented none other than a stripper. Yes. Oh, wait, hold a second. He's been representing one in today's world in 2023 and 2024, as he's been acting as a lawyer and not a judge for LIEnette. Now, back in the full documentary that Judge Craig DeThomasis is highlighted in, he represents an individual who was called to a frat party, who later makes some pretty rancid allegations against the boys at this frat house. And they filmed everything. Now, I want to caution you, do not try and watch this documentary if you are not ready to see unedited, unblurred, it is raw exactly what happened. But since these boys filmed exactly what happened, they were actually able to be declared innocent. Now, I realize what they were doing with that woman there was not innocent behavior, but it was consensual behavior. And she made false allegations against them. Judge Craig DeThomasis, or Judge Grudge, back then, as a lawyer, is representing her. And what happens? She makes false police reports and she ends up in jail. Not only does she end up in jail then, this woman can't stay out of jail. Reminds me of somebody else we know not too far down the street in Otter Creek.
She's going to jail for lying.
But this isn't the only thing on his list with being involved with some individuals that are deep in, we'll just say, actual, we'll drop the S, activities. So as you can see here, oh, hold a second. Wrong screenshot. Give me one moment. There it is, right there. We've been tipped off that Craig decided it was acceptable to testify as a character witness on behalf of former Assistant State Attorney William Ezel of Gainesville to have his law license reinstated. Ezel pled no contest to video voyeurism, a felony of the 3rd degree. And Craig thinks it's okay. What this man did was he took his cell phone into a tanning salon and over the walls tried to video and successfully videoed individuals with no clothing on whatsoever. And who comes to his aid? That's right, Judge Grudge. If that's not enough concern, already in the Levy County Courthouse, the victim's advocate, Amanda Martin, who is supposed to be representing me as the state presses charges against LIEnette, unleashes her son to assault me as I'm having dinner. Now, that's a pretty huge issue right there. And Amanda Martin right now is under an independent investigation being held by the state attorney. I have a major concern with inappropriateness of Joshua Silverman representing LIEnette in front of Craig DeThomasis, because Joshua Silverman asked Judge Grudge to preside over his divorce in a county where he does not live. If you've ever been divorced, you know the divorces happen where you live. And how in the world did it go from Alachua County over to Levy County to be heard by his good bud? Oh yeah, Craig DeThomasis. My personal feeling, extremely unethical. Number one, to take your divorce from one county to have your buddy hear about it in the next county. And then you're now representing Otter Creek's own ordained minister. Yeah, that's right. Who's a stripper on a pole. This isn't looking too good in my direction right now when you got these good old boys all tied up in their network together around all these inappropriate actual escapades. And now you got somebody who is in the profession across the courtroom saying that I'm stalking her when this individual stalked me and begged for money in Otter Creek. Placed a temporary injunction on me, not based on what I've done, but based on what LIEnette is lying, saying that others have done. Now, let's not forget, I already have a civil protection order out of Ohio on LIEnette and John CROOK. And what does Judge Grudge have to say about that? He ignores it. As a matter of fact, legally, by good faith and measure, he has to accept it. He has to uphold it under Florida law and federal law. No, instead, what he does is he puts a temporary injunction on me that, number one, takes away my freedom of speech. Number two, takes away my right to bear arms. Number three, takes away all my rights to all of my property within a 500 radius of their property. When they stalked me and bought 1.66 acres right across the street from me intentionally, on purpose. And then he takes away my legal right to access all of that property on the road. This is what it sounds like. This is what it looks like. Based on the totality of the circumstances presented to this court. Now let's just pause right there. He's not actually received any evidence from LIEnette yet. Nothing has been submitted as evidence in the court. But based on the totality of the circumstances presented in this court, in prior pleadings, and in the form of evidence presented as a prior hearing of record held on 11/29/23, and based on the extension of the injunction relief due to the respondent's request to continue the hearing of 12/6/23, which was previously set with both his and counsel's knowledge without objection. Oh boy, he loves throwing that in. When the counsel doesn't object, he loves throwing that in and saying it over and over and over again. Okay, no objection. And in consideration of the issues implicated regarding the potential prejudice to the petitioner, if such conditions which follow were not imposed, it is therefore, by the way, this is just a whole bunch of legalese stuff saying that LIEnette whined and cried. She fake cried. And now she also submitted a supplemental information that stated that my lawyer tried to pay her off to make this whole hearing go away. I never, ever have given her a penny, nor would I ever. So the whole aspect of paying her off is ridiculous. And what I have done is I paid a lawyer to actually send her a cease and desist. I've paid a lawyer to actually make sure that we have civil protection orders against her. I've paid a lawyer over $80,000 right now, and it just keeps ticking and ticking and ticking, and the price keeps going up and up and up. I would never give this woman a single penny. What I would do is spend every last penny to keep her out of my life and to fight for my rights and my freedoms. So Judge Craig DeThomasis, which goes on to say it's therefore ordered and adjudged as follows. In addition to all conditions and restrictions previously imposed and set forth in the extended injunction for protection against stalking, the following restrictions and conditions are imposed. The respondent, and get this, and or anyone under his control. Just so you understand, if you are watching this right now, according to Judge Craig DeThomasis, you're under my control. According to LIEnette, you're under my control. I'm talking to a camera. The camera doesn't even do what I ask it to do. How in the world am I going to get people who have a free mind and free will to act and to talk and to do what they want, not what Jeremy wants? How could they be under my control? I can barely get the camera to work. But here we go. The respondent and or anyone under his control. Again, keep in mind, he means you. Or anyone employed by him and or any way under his direction, including but not limited to any or all administrators, any form of social media. YouTube is the largest media platform in the world. And what do we need? We gotta have citizen journalist, or this kind of tragedy actually happens, has the responsibility to assure that he does not publish in any form whatsoever, utilizing any media platform or any conduit of information of the name, of the image, of the likeness, or the information, the data, the photography, the videos related to or pertaining to the petitioner or her minor child. Just so you understand, Craig DeThomasis just completely and totally attacked, annihilated the First Amendment, my freedom of speech, and yours. Let's look at the other illegal things he's done. Right here, it says respondent shall not go to, in, or within 500 feet of, and following down there is LIEnette's address. Now, LIEnette posts her address, her phone number, her email address all over the internet. She acts as a public figure with all of her various Facebook pages and donation requests, and the list goes on and on and on. Although I'm going to redact it, but he's now saying I can't be within 500 feet of her address. You understand, the only thing between her address and my address is a 12-foot section of road. In other words, from the point of her address and a radius of 500 feet into my 70 acres, he is now illegally taken away from me. And if I would go into that portion of my owned property that the United States of America, the Constitution, gives me a right to be on and tries to protect to make sure he can't take that right away from me, I get arrested. Now, how insane is that? It gets worse. I live my life publicly online, and therefore privacy is a premium for me, and so is protection. As a matter of fact, after being stalked by LIEnette and John CROOK, you'll hear in one, or if not many, of the hearings, we have spent over $1 million to protect ourselves from them and people like them. And that means we've had to find pieces of property to actually make sure they're secure and that nobody could ever do this to us again. We have to put up more security cameras, more gates, more codes, more locks. It just goes on and on and on and on. And what does Judge Craig DeThomasis do to me? He says, I can't possess any firearms. Interesting, because it is John CROOK who actually pulls a firearm on me as I'm driving past not only his property, my property, the road accessing my property. And then he stalks me, and the fool actually films himself stating that he's going to wait for me on my property. And when I come out, he tells me, touch my truck and see what goes boom. Now, there's 2 incidents with firearms. And LIEnette, she publicly posts on Facebook that she's going to pop a cap in my beep. You can fill in the blank there. So the one individual who has never made any threat with firearms whatsoever, uses them responsibly for protection, gets them taken away. And I'm sure if you're a true fan, you know that we are true treasure hunters, and we find firearms and ammunition all the time. And now I can't use any of it to protect myself, nor can anybody around me have it to protect themselves or me either. For those keeping count, he's taken away my freedom of speech. He's taken away your freedom of speech. He's taken away my right to bear arms. He's taken away access to all of my property. And he's actually keeping me from driving on the public road that accesses all my property. Now, there's a big 5 right there. You think he hit me? He hit me pretty hard. If you see anything wrong with this, there's one place to go. It is the Florida Judicial Qualifications Committee. This is a committee where you can actually submit a grievance. You can share what the problem is anonymously. No one should try to contact the judge. No one should try and contact my stalking neighbors. Nobody should do anything that isn't appropriate or illegal. You have the appropriate routes to go if you see something wrong. Now, everybody viewing doesn't see something wrong. So if you don't see something wrong, don't worry about it. But I love Levy County Sheriff's own motto. If you see something, say something. There are the appropriate routes and the appropriate authorities to actually share that with. As a matter of fact, I'm going to go ahead and I will share Florida's Judicial Qualifications Commission, which is an independent state agency charged with, they exist to hear from people like you and me, charged with investigating allegations of judicial misconduct and disability against Florida state judges. This is their whole being and reason why they actually exist. So it's okay. And I'm going to go ahead and pin their website in the pinned comments on this video. Now, let's take a look at some of the issues I have with this judge. 6 days ago, I filed a third motion to disqualify Judge Craig DeThomasis based on his bias, based on his partiality, okay? And he's not said a word. Matter of fact, there's been plenty of motions that have been filed that he has completely and totally ignored. All of them. And all of those motions that have been filed, he can't say anything about them until he actually rules on this 61-page, it is a piece of art, motion to disqualify him for the third time. 6 days, nothing but crickets, until he has ordered that myself, LIEnette, and my entire legal team, which is 3 people, must be in court tomorrow at 1 o'clock. Now, one of those individuals you've heard so many times, I'm sure you can quote Judge Craig DeThomasis over and over again. Mark Feather, co-counsel, said he could have this done in 15 minutes. Well, Mark touched base with me. He said, Jeremy, he obviously has an extreme issue with me. He goes, do you think it'd be appropriate if I no longer co-counsel, if I drop out? And I said, you're my lawyer. I trust you to know what's best. And he says, I think it's in your best interest. And I want you to understand that Mark Feather is a highly respected individual in this community and a great lawyer and has done nothing but the best that he could for us, despite a biased, very, very biased Judge DeThomasis. Nobody knows what to expect tomorrow. Why would Judge DeThomasis say that every single lawyer on the legal team must be present? What we do know is he has to rule on this, say yes or no, before anything else can happen in this case. So I am going to share portions of this with you here. And it says right here, we've got, for the third time, the respondent, Jeremy Hales, moves to disqualify Circuit Court Judge Craig DeThomasis for bias pursuant to Section 38.10 Florida Statute, Rule 2.330 of the Florida Rules and General Practice of Judicial Administration, and other authorities cited herein as grounds therefore as states. A, Florida R General Practice and Judicial Administration 2.330 D1 requires a circuit judge to disqualify himself if a party fears that he or she will not receive a fair trial or hearing because of specifically described prejudice or bias of the judge. Now, you have to understand, this says if I fear that I'm not going to get a fair trial, the judge must disqualify himself. Now, one disqualifying motion has already been submitted, and he denied it. Not only did he deny it, he wrote a book report on why he denied it. And then a second one was filed, and he denied it. And then he wrote another huge book report about why he denied it. Now, what should have happened, he should have said, yes, I'm going to go ahead and disqualify myself with no explanation whatsoever. Or, no, I'm not going to disqualify myself with no explanation whatsoever. The fact that he keeps writing books, the fact that he's going in pages of single-spaced type and he is defending himself against my fear, and he actually goes on to say that I'm not normal, I'm unreasonable in my fear, saying that any reasonable person would have no fear of a fair trial. Well, I like to think myself as fairly reasonable. And I like to think of all of our viewers as fairly reasonable. And I think that the vast majority of us understand that he holds a tremendous amount of bias. He is not impartial as he should be. A judge should be sitting on that bench listening. And yet what that judge continues to do is litigate for LIEnette when she's a pro se, and then litigate with Silverman while he's now representing LIEnette. Do you understand? This is a litigating bench judge. A judge should not be doing any of these things. Shouldn't be guiding, shouldn't be directing, shouldn't be. The judge should be listening to both sides, present everything. And yet this judge continues to plead LIEnette's case or even argue LIEnette's case for her against me and my lawyer, my team. Now, if that's not bias, I don't know what is. The fact that he even goes on to argue why he should not disqualify himself is in itself a tremendous bias. You may recall in a previous hearing where Judge DeThomasis says, Mr. Hales needs to hear this. When the petitioner comes and states these things about him, I must take it as truth. And he goes, because it's the law. Well, he also has to take it as truth because it's the law when I say I fear having a fair trial. But what does he do when I come with the truth that I fear having a fair trial? He throws it out the window like it never existed. Yet again, name calling after he actually admonished my legal representation in regards to name calling. He alludes that I'm unreasonable. And I'm not quite sure, but I think that could be name calling. Matter of fact, page 2 right here, point E, it says it's irrelevant whether the judge agrees with the facts of which the fear is based. It is the reasonableness of the party's belief, not the court's perception of its ability to act fairly, that matters. In other words, the only thing he can take into consideration is, do I fear having a fair trial? And the answer is absolutely. And I think if anybody was in my seat in this courtroom, they would fear the aspect of having a fair trial as well. Yeah, that even means Silverman. If Joshua was sitting where I'm at, if LIEnette was attacking Joshua, pretty sure he would fear whether he was getting a fair trial or not. Oh, and his paralegal, Brent. If Brent was sitting where I'm sitting, I'm pretty sure Brent would say, yep, I fear getting a fair trial. You know who else would fear getting a fair trial if they were sitting where I was? Craig. If Craig was on the other side of this, sitting where I'm sitting, I guarantee you he would fear a fair trial. Page 6 says, despite the judge's bare contention that he was not passing judgment on the truth of the facts alleged, he did so. And for example, Judge DeThomasis took issue with Hale's very assertion that as a result of occurred during the course of a non-evidentiary hearing on January 23rd, 2024, Hales had a well-founded, objectively reasonable fear of not receiving a fair trial before Judge DeThomasis. Paragraph 9 of this order, however, directly disputes. Do you understand that this judge is trying to act like a lawyer and he's arguing with my fear? He's disputing my fear. He directly disputes Hale's fear, stating, any objective review of the proceedings held on 1/23/24 would not cause a reasonably prudent person to fear not receiving a fair trial. So who's name calling now, Craig? I'm not reasonable and I'm not prudent, apparently. But in all reality, I think I'm a bit more successful than Craig has ever been. Well, at least with YouTube. Remember, Craig tried to use YouTube to get elected as a judge, and he failed. Actually, one of his students got elected as a judge. And then when one of the judges in the middle of the night, out of nowhere, stepped down from his role, Levy County Courthouse was in a bit of a predicament. And Governor Ron DeSantis actually appointed DeThomasis because they're good buds. They both love the Grateful Dead. And here we are. Right after he gets appointed, then you have COVID. The world shuts down. And what does that mean? It means Craig DeThomasis has not been a judge sitting in that courtroom for 40 years, as he would like to assert, or as he would like to imply in one of his comments. It means that he was a criminal defense attorney for the vast majority of his vocational career. And he is a new judge cutting his teeth in the courtroom as he's trying to knock all mine out, taking my First Amendment rights. Page 8 and point 16. Judge DeThomasis' order does not consist of mere reports of perceived unprofessionalism, but instead, summarily, repeatedly, and inappropriately condemns all three of Hale's attorneys, indicating, number one, Attorney Feather is not worthy of belief because of what the court perceives as a misrepresentation made by Feather on 11/29/23 as to why Hales was unavailable on November 30th, 2023 to conclude the hearing that did not finish the day before. Well, maybe hearings would finish if he would be quiet and actually listen. So let's keep going. Number two, Attorney Feather's violations of certain administrative orders addressing video recordings of court proceedings promulgate by Florida Supreme Court and the 8th Judicial Circuit justified Judge DeThomasis' repeated and hostile open court accusations of misconduct, notwithstanding that the Chief Justice Mosley was in charge of handling this matter. Number three, Attorney Inkles misrepresented to the court's judicial assistant that the nature of submission of a memorandum of law containing case law analysis as being nothing more than electronic copies of cases. And number four, Attorney Shockett conducted a video deposition of the petitioner without complying to Florida rules for civil procedure. By the way, his whole thing was he didn't take proper notice of the video deposition pursuant to subpoena duces. I can't even say those words. They're Latin. All right. Law has Latin. I don't speak Latin. Basically, in a nutshell, what Silverman and DeThomasis said is, oh, the videographer wasn't posted. Well, you can't post it when you get an order for your video deposition because you don't know who's actually going to be doing it yet. That's insanity. You don't know who's going to do it. So you say, oh, you're going to have a video deposition, which she knew she was going to have a video deposition. She was ordered to do a video deposition. You can't post who the videographer is going to be until it's assigned. And therefore, the other aspect of it is once LIEnette sits down for that video deposition, any rights are waived. She started it. If she didn't make a complaint from the beginning, it's done. It's a done deal. And so all of this continues to show bias. More bias and more bias and more bias. It's noteworthy that the majority opinion in Manuel versus Estate of Manuel Supra was authored by Judge Cyclin, who expressed the very same concern that is what has been a dissenting opinion just 2 years ago in MD Parker Associates versus Connor, in which a trial judge should resist all temptation to become indignant and should promptly and succinctly, some words I can't even say, they're so big, rule on the motion of within a few words or less. Communicate nothing further and move on. You realize this man writes books arguing why he's the best thing since sliced bread instead of saying no or yes every time he gets a motion to disqualify. Judge DeThomas's single-spaced order denying Hale's second disqualification motion went well beyond simply finding Hale's motion to be legally insufficient. It addressed and it challenged the merits of the motion, exceeding the proper scope of inquiry for ruling on a motion to disqualify. In other words, what he did was wrong. All he has to say is yes or no. That's all he's supposed to say. Yes or no. He writes volumes, okay? And wholly disregards Florida law requiring a trial court to view a motion to disqualify through the lens of the litigant, not on how a judge grades him or herself as the ability to act fairly and impartial on Craig DeThomasis. Mark Feather! Page 14. 61 pages here. Point 30, paragraph 7A references a statement made by Attorney Feather to the court at the end of the day on November 29, 2023, regarding the possibility of concluding the hearing that had not finished the next morning at 9 a.m. Mr. Feather's words were, "No, Your Honor, Mr. Hales is having to address matters in Ohio court related to this situation. He has to be there tomorrow morning." The court thus scheduled conclusion of the hearing for December 6, 2023. Point 31. From Feather's statement, the judge assumed. We all know what happens when we assume, right? The judge assumed that Hales had to be present at a court proceeding the next morning in Ohio court, rather than considering the possibility that Feather just simply misspoke or failed to phrase his response more articulately. The judge immediately reached the adverse conclusion that Feather intentionally displayed a lack of candor with this tribunal or obtained a longer continuance for his client based on misrepresentation. Point 32. Ironically, on the electronic recording of the January 23rd hearing, the court, speaking rapidly, stated, "Anyone after this judge has spent 40 years almost on a daily basis in a courtroom." Point 33, remember that. Although this statement gives the impression that the Judge DeThomasis has been serving as a judge on the bench for 40 years, we all know that's not the case. Immediately assuming that the judge lied in making that statement when he merely did not articulate his words carefully would be absurd. Of course, nonetheless, in his order, Judge DeThomas continues to impugnate Feather with this statement months later after having reached a negative conclusion without ever affording Feather an opportunity to be heard. Such the conduct is the antithesis of impartiality. Understanding that all of a sudden, the judge is yelling at Mark Feather because Mark Feather goes, "Listen, all I need is 15 minutes. Let's look at the law." Jeremy didn't break the law. All we have to do is look at the law. And then he says, "Well, we're not going to get this done today. We gotta pick another day. Let's come back tomorrow at 9 a.m. And Mark Feather turns around to me and I go, "No, I gotta fly to Ohio tomorrow, take care of things with the Ohio court system." And he repeats what I say, which I did have a flight that next morning at 9 a.m. I was at the Tampa airport. And he has copies of my tickets. And I went home. And the following day, I had my scheduled meeting with my lawyer in the law office, where all the paperwork was filed for contempt of court against LIEnette and John CROOK. And it was all notarized as it needed to be. And that court case has been heard. But nobody said there was a court proceeding that day. Nobody said there was a hearing that day. It was Jeremy has to fly to Ohio to take care of these Ohio court issues, which I did. And yet Judge DeThomasis thinks it's okay to say, "Well, I've spent 40 years in a courtroom every day," alluding that he's been a judge for 40 years. Listen, this judge has not been a judge for 40 years. This judge is in the infant stages of even being a judge, and frankly, not doing a very good job. Page 21, point 45. A trial judge failure to remain neutral during the proceeding is also a due process violation that requires reversal based on Sparks versus State. Judge DeThomasis' adversarial conduct towards attorney Shockett has created and exacerbated Hale's fear of not receiving a fair trial by this judge. Point 48, as shown by the video of this recording, Judge DeThomasis' hostility towards counsel, only my counsel, not LIEnette or her counsel, toward counsel was not just evident in his words, but in his indignant and sometimes sarcastic tone, voice inflections, his body language, and even his finger pointing, either at Shockett or audibly down onto his papers to punctuate what he was saying. Page 28. Double standard in determining legal sufficiency. So, point 60, for example, in addressing Preston's supplemental affidavit, that's where she says that Feather tried to bribe her to make this all go away, to pay her off, which would never, ever happen. Supplemental affidavit to her injunction petition, which caused a temporary injunction to be entered on me. Judge DeThomasis stated, when the court receives a petition or a supplemental petition as a matter of law, this court must accept what's alleged in the petition as true. Period. End of story. Why? Because the court must do so. No choice in that. Those are all his words. Point 61. By the judge's own description, one would believe he had no discretion in granting petitions involving legal sufficiency determinations. Preston's injunction petition was merely set for hearing. The judge did not grant a temporary injunction until she filed a supplemental affidavit. It is noteworthy that in her supplemental affidavit, she specifically named Mark Feather in her allegation. Point 62. By contrast, the judge did not accept Hale's alleged in his two prior motions to disqualify him as true. Period. End of story. This means he did not apply the same standard to Hale's two prior motions to disqualify him, which are also reviewed for legal sufficiency and contain not only allegations recognized by controlling authority as meeting the standard for disqualification, but transcript excerpts in court proceedings. In other words, LIEnette can say anything to him, and it's true. If Jeremy says it, nope, it's a lie. He might need to figure out what LIEnette's real name is. LIEnette. Double standard for procedural rules. Point 63. Yeah, there's a lot of them. Judge DeThomasis employed a hyper-technical review of Shockett's notice of video depositions that were served on Preston and a witness, John Crook, in an effort to foreclose his arguments to obtain discovery necessary to prepare his case. Okay? Shockett's notices were also served before Preston's attorney was involved. So all these notices for depositions were before Joshua Silverman was involved. And several hours of her deposition were taken before he got involved. Point 64. Preston's attorney had only filed a limited appearance. Now you have to understand, when Silverman filed for a limited appearance, first of all, that motion had to be heard and granted, and that's the only thing he can do for her. But that's not what he did. Preston's attorney had only filed for a limited appearance to argue for a continuance. That's all he was legally allowed to do, but DeThomasis let him do whatever he wanted. This means that he could not permissibly file a motion for a protective order, nor did he. Yet, not only did the judge permit ambush by allowing, over objection, Preston's limited appearance attorney to make an unauthorized and unnoticed arguments to exclude discovery items and limit the taking of further depositions, but he also allowed Preston's attorney to make unauthorized and unnoticed arguments about discovery directed to a third-party witness to whom the attorney did not even represent. And what he's referring to, or what she's referring to, what I'm referring to, is the deposition of John Crook. Silverman didn't represent John Crook. John Crook isn't represented by anybody. And Silverman showed up for the deposition and then cut it off, stating that it was harassment. Let's keep going. 66. Shockett's notices of taking video depositions, including all information required by 12.310 Florida R. Fam. Law P, except the actual name of the videographer did not appear in the notice, as it was unknown. You don't know the name of the videographer until they're appointed. Nonetheless, the error was waived under the same rule. Because LIEnette showed up for the deposition, it doesn't matter. She waives any errors. As Preston, a pro se litigant at the time, appeared for the deposition and is held to the same standard of a reasonably competent attorney. Number 67, Judge DeThomasis selectively overlooked. In other words, he gets to pick and choose. He gets to cherry pick what laws he wants to uphold against me and then overlook any laws that would be against LIEnette. Overlooked Rule 12.330D1 and gave himself leeway to seize on the technical admission of the videographer's name in the notices, again, which were waived in any event, so it didn't matter, condemning petitioner's deposition as a videotape that was not in conformity with the rule, when in all reality it was, because she waives it when she shows up for the deposition, which then became a mantra throughout the rest of the proceeding, as well as being mentioned in the actual order. 67, the judge's critical comments on Hales' use of Preston's video deposition to make it apparent that the judge disapproves of Hales' earning income with his YouTube program. Oh, he doesn't like entrepreneurship. He doesn't like capitalism, free enterprise. He doesn't like business, apparently. Go figure. That's funny because the courts actually charge you for the video. So courts are making money on the video, but I'm not allowed to make money on the video, which is public information. Remember that, it's public information. When Shockett wanted to show the court some of the excerpts from Preston's deposition to make it clear why he needed the additional time for Preston's deposition, Judge DeThomasis looked at him incredulously and said, "So now you want to disseminate, or you want to show all this information in court?" That's what the deposition is for, to show in court. A portion of the video. 69. On the other hand, when applying the rules of the procedure to Preston's side of the case, the judge was not at all rigid or technical. After allowing Preston's limited appearance attorney to make 1, unauthorized and unnoticed arguments to exclude discovery items, 2, to prevent the taking of further depositions, and 3, to argue about the discovery directed to a third-party witness whom the attorney doesn't even represent, John Crook. The judge did not deem these as transgressions. Rather, he merely dismissed these acts by saying it will all be remedied when the files a notice of an appearance, and the court will acknowledge it. And notwithstanding that no motion for protective order has been filed on Preston's behalf to limit or terminate further taking of the depositions, the judge stated he would not permit her to take any more depositions or to be deposed further. In other words, he's stopping my legal right for due process. I could go on, and there's just so much here. There's so much. The reality is this. This judge has black robe fever. He thinks he is God. He has taken away my constitutional freedoms and rights. Freedom of speech, and he took away yours as well. He's taken away my freedom to bear arms. He's taken away the right of others, their freedom to bear arms if they're associated or with me or near me. He's taken away access to all of my land and property. He's taken away my freedom to drive down the road to access all of my property. He's taken away the right of due process. Let me be very, very clear. This is not a judge who should ever be a judge. And if you come to the same conclusion as well, remember, I've posted in the comments a link where you can file an anonymous complaint against Craig DeThomasis. Don't ever contact him or LIEnette or Crook or anyone else directly. It's agencies. That's what this group is for, so that you contact them and they will investigate.